1932. Mr. Jones does appear in custody. He's represented by Ms. Smith and also Mr. Colvin, Mr. Rubenstein, and Mr. Wader here for the people. We are outside the presence of our jury, but I've been notified by the bailiff that our jury has reached a verdict. Anything before I invite the jury back into the court, Mr. Rubenstein?
Not from the people, Your Honor.
Mr. Colvin?
Defense.
All right, thank you. I'll go ahead and call for our jury. I, Joanne, are ready for the jury. All right, thank you so much. I do just want to thank everybody for how everybody behaved during the trial, and I appreciate that. The same thing goes for the verdict. Please don't have any expression of happiness or dislike of the verdict, anything like that. It would just be disrespectful to our jury, so I'd appreciate it so much if we continue with that decorum. Thank you. Please rise for our jury.
Ladies and gentlemen, Mesa County District Court Division 10 is now in session again with the Honorable Brian J. Flynn presiding.
Thank you. Please be seated. For the record, our jury has now joined us back in the court. And welcome back, everybody. And I've been informed by the bailiff that our jury has reached a verdict. And Ms. Chase, are you the foreperson of our jury?
Yes.
And you have all the paperwork with you, the verdict forms and instructions. Would you mind giving those to our bailiff, and she'll bring them up to me, please? Thank you. Great. Thank you. And the verdict forms do appear to be in proper form and order. Please listen carefully to the reading of the verdicts, ladies and gentlemen. There may be some questions for you after I read the verdicts. Jury verdict, count number 1, charge of murder in the first degree, felony murder. We, the jury, find the defendant, Lester Ralph Jones, guilty of count 1, murder in the first degree, felony murder. That is signed by our foreperson. Jury verdict, count number 2, charge of murder in the second degree. We, the jury, find the defendant, Lester Ralph Jones, guilty of count 2, murder in the second degree. That is signed by our foreperson. Jury verdict, count number 3, charge of second degree kidnapping. We, the jury, find the defendant, Lester Ralph Jones, guilty of count 3, charge of second degree kidnapping, and that is signed by the foreperson. Do you wish to have our jury polled, Mr. Colvin?
The defense so requests.
Okay, thank you. Ladies and gentlemen, I do need to ask all of you, individually if the verdicts that I've just announced are your verdicts and also the verdicts of the entire jury. So when I call your name, if you would please answer the question either yes or no. Mr. Spears, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Mr. Woodring, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Mr. Barnes?
Yes.
Mr. Barnes, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes, sir.
Ms. Keim, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Ms. Massey, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Ms. Chase, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes, sir.
Mr. Field, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Ms. Gumber, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Mr. Logsdon, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Ms. Schwartzen-Truber, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes, sir.
Mr. Klein, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury?
Yes.
Mr. Murphy, are the verdicts that I've just announced your verdicts and also the verdicts of the entire jury? All right, thank you, sir. And just for the record, all of our jurors have answered affirmatively that the verdicts are their verdicts individually and also the verdicts of the entire jury. I have one other jury instruction that I need to give to you at this time, ladies and gentlemen. That's as follows. You have now completed your duties as jurors in this case, and you are discharged with the thanks of the court. The question may arise whether you may now discuss this case with the lawyers, defendants, or other persons. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not. If you talk to them, you may tell them as much or as little as you like about your deliberations or the facts that influence your decision. If any person persists in discussing the case over your objection or becomes critical of your service either before or after any discussion has begun, please report that to me immediately. That stock instruction that I have to give you, ladies and gentlemen, never fully expresses my appreciation for your service to our community, especially in cases that take this amount of time and attention. I know that it's an awful, very big sacrifice that you've made for the community. So I really, truly appreciate your time and attention and the hard work that you've given us on this case. Today's all of those things. It's just been tremendous on all of your parts, and I really express my full appreciation for you. And I know the parties feel the same way about that as well. So just thank you so much for your time and attention. The bailiff told me that you want to speak with me back in the jury room. It'll just take me about 5 minutes to do some things in the courtroom that I need to do, and then I'll be right back to speak with you back in the jury room. Thank you so much. Please rise for our jury. All right, thank you. You can be seated. And for the record, our jury has left the courtroom. And pursuant to the jury's verdicts, I do at this time enter a judgment of conviction for count number 1, the charge of murder and the first-degree felony murder. With regard to count number 2, does that merge?
The defense's position is that both counts in 2 and count 3 would merge into count 1 as they necessarily are included within the elements of the first count.
Mr. Rubenstein.
Judge, I believe count 2 merges. I'm not sure count 3 merges. I think it's required to run concurrent, but felony murder requires that a kidnapping or attempted kidnapping occur. There's other elements as far as one or more persons, and I don't believe that charge actually merges, but I do believe it requires concurrent sentencing, so that's what I would ask. One thing I'll also let the court know is that given the verdict in count 1, the Bergfeld family has expressed that they understand that the sentence is non-discretionary and they would prefer to have this move forward as quickly as possible. At this time, based on that, we are going to dismiss the habitual criminal charges and ask the court to go directly to sentencing to today. My understanding is defense counsel is not objecting to that request.
Mr. Colvin.
That's correct, Judge. In light of the dismissal of the habitual criminal counts, defense waives the pre-sentence report. We're requesting immediate sentencing.
Okay. People are waiving a pre-sentence report?
We would do that as well, Your Honor.
All right. How much time do you expect it'll take to make your arguments? There's only
A few minutes.
Mr. Colvin.
Less than a minute.
Okay. All right. Thank you. Does anybody have any law with regard to count number 3 and your positions?
I do not, Your Honor.
Nor do I.
Mr. Colvin. All right, I am at this time not entering a judgment of conviction by agreement of the parties with regard to count number 2, the charge of murder in the second degree. However, I am entering a judgment of conviction for count number 3, that is second-degree kidnapping. And I do so as I find that count number 3 does not merge with count number 1 and the elements of first-degree murder, felony murder. So it's for that reason. Well, I find it doesn't merge because of the difference in the elements of the offenses. Your argument, Mr. Colvin, with regard to sentencing?
Judge, we would ask the court, no, Mr. Jones doesn't wish to make any statement in sentencing at this time. That's my understanding from consulting with him. We believe he's entitled to 767 days pre-sentence confinement. We would ask the minimus reflect that. Mr. Jones is asking that the public defender be appointed for purposes of appeal. It's my understanding from previously appearing in front of you, you prefer to have a motion in that regard, and I'll be filing such shortly.
Okay. Yeah, I think there does need to be a motion filed just with regard to your finding of indigency if the defendant continues to be found to be indigent by your office, and then, of course, the prosecution's entitled to respond if they wish.
But we'll follow up on
Okay.
that, Judge.
All
We
right.
have nothing further to say.
All right, thank you. Mr. Rubenstein.
Thank you, Your Honor. Your Honor, previously we had emailed the court a copy of the penitentiary pack during the trial for purposes of a judicial notice that the court had taken of the defendant's prior convictions as it related to impeachment. I have the original for the court if the court wants that, if the court does not want more things in the file, because I've already sent the court a copy of that as well. We are asking the court consider this in imposing the sentence on count 3 and ask that the court impose the maximum 12 years in the aggravated range, given the defendant's prior history of a similar type offense and the fact that it was for an attempted kidnapping charge. I know the court is aware of the factual basis for that. I understand and believe that that is required to run concurrent with the sentence of life without parole that he will be receiving on count 1. So if the court wishes, I can approach with this. Otherwise,
I still have that, and we uploaded it into our system.
if the court wants to just use that, that's fine with us. Beyond that, we would ask that the court leave restitution and cost of prosecution open in this case. The costs, because of the 2 trials, are fairly substantial, and there's also quite a bit of restitution to, I believe, victims' comp and to the family. So we're asking that the court leave that open for 90 days so that we can get the appropriate paperwork filed. And I have no quarrel with defense counsel's representation on the pre-sentence confinement.
Thank you. Anything else you'd like to add, Mr. Colvin?
No objection to leaving it open, just reserving our right to object to whatever amount is sought, if it's appropriate.
Okay. All right, thank you. All right, thank you. I have considered the arguments of counsel. Also, of course, I'm familiar with the factual circumstances that are alleged, and that the jury considered and found the defendant guilty beyond a reasonable doubt. Considering the nature and circumstances of the offenses, and also deterring the defendant and other people from committing these same crimes, I do consider developing respect for the law, protection of the public, and finally do consider Mr. Jones's character and potential for rehabilitation. With regard to count number 1, murder in the first degree, the only available sentence to the court is a sentence of life in the Department of Corrections without the possibility of parole. And so I am imposing that sentence for count number 1. I do find that there are 767 days of pre-sentence confinement, With regard to count number 3, second-degree kidnapping, which is a Class 4 felony, the maximum sentence allowed under Colorado law is a period of 12 years in the Department of Corrections plus 3 years of mandatory parole. That maximum sentence is if the court were to find extraordinarily aggravated circumstances based on the defendant's prior criminal record. I do find that those extraordinarily aggravated circumstances do exist, given the defendant's prior record, including the number of felony convictions, the similar conviction that was mentioned by Mr. Rubenstein. So for count number 3, the defendant is sentenced to 12 years in the Colorado Department of Corrections plus 3 years of mandatory parole. That sentence is to be served concurrently with the sentence imposed for count number 1. I do find for count number 3 that there are 767 days of pre-sentence confinement. The sentences do also include all of the mandatory fees, costs, and surcharges that are required by Colorado law, and the protection order does remain in effect throughout the period of the defendant's sentence. Is there anything I forgot to mention, Mr. Rubenstein?
Just that restitution remain open for
I
90
think
days.
it is left open under Colorado law for a period of 90 days, so
Thank you, sir.
if you do wish to file such a request. And then, of course, I'll give the defense an opportunity to respond if such a motion were to be filed. Anything else, Mr. Colvin?
Not for the defense,
Okay.
thank you.
The jury mentioned, maybe I already said it, they only want to speak with me but not the lawyer, so,
Thank you.
okay, thank you so much. We're in recess. There's no judgment of conviction down here. You can just put it merged. Okay, perfect. Yeah, sounds good. Thank you.